Now, Mr. Ramlogan, are you addressing us first?
I am indeed, my Lord, yes.
Yes, very well.
Thank you, my Lord. My Lord, in this appeal of Satyanand Maharaj versus the Attorney General, I appear with Ms. Kate O'Reilly and Mr. Adam Riley, both of the British Bar, my learned friend Mr. Thomas Rowe, QC, and Mr. Fayed Hussain, Senior Counsel, together with Ms. Natasha Jackson of the UK Bar, appear for the Respondent. I'm very grateful to the board, my Lord, for accommodating this hybrid hearing and the hearing of these appeals together, but consecutively. Clearly, a prudent use was made of the time. My Lord, the issue in this case is it turns on a discrete point. And whilst we adopt the submissions in Suraj, this appeal is different in that even if Suraj does not succeed, we say that the discrete point raised herein is one that should be deserving of consideration as an independent appeal. At the High Court, the trial judge found that the regulation in issue was unlawful and it was void for uncertainty. The state, he did not, however, go on to find or grant any constitutional declaratory relief, and we appealed, and there was a cross appeal by the state against the finding that the regulation was unlawful in any material respect. And as a result of that, we had the Court of Appeal dealing with the matter. The question of damages, it was agreed from day one in the High Court between both parties, is a question to be answered by a trial and an assessment of damages if needs be. Can I start by quickly taking the board to page 1429 of the Suraj bundle, which is where we'll find the regulation in issue. And this is regulation 23, and it's dated the 1st of August 2020. And regulation 2 says, during the period specified in regulation 16, a person shall not, without reasonable justification, be found at any public place where the number of persons gathered at any time exceeds 10. B deals with sporting activities, where 25 persons is a limit, and C, at a beach or river, pond or stream, and again the limit is 10 persons.
Mr. Ramlogan, can I just ask you, could you repeat the page number? I think I may have got it down wrong.
Oh, I beg your pardon, my Lord, it's 1429, 1429.
Thank you very much.
This is the regulation in issue in the case, my Lord. And I shall just reverse a bit, but at 2 says, during the period specified in regulation 16, a person shall not, without reasonable justification, A, be found at any public place where the number of persons gathered at any time exceeds 10, B deals with sporting activities where the limit is 25 persons, and C, a beach or river where the limit is 10 persons. Sub-regulation 2 says the limit of persons at A, religious or ecclesiastical services, or any other religious gatherings, including funerals, weddings, and christenings, may exceed the number set out in subsection 1, provided that they comply with the guidelines for places of worship issued by the Ministry of Health, and B, other public places may exceed the number provided the Chief Medical Officer passes guidelines for a specific purpose, which doesn't concern us here. Now, sub-regulation 3 says a person who contravenes this regulation, and we say this regulation means the regulation 2 in its entirety, this regulation commits an offence and is liable to summary conviction to a fine of $50,000 and imprisonment, a term of imprisonment of 6 months. Now, my Lord, we make the following observations. Our core submission is that this provision criminalizes or purports to criminalize those who are found in attendance at a gathering in excess of 10 people where the gathering does not comply with non-statutory guidelines. The first point we make is that it begins with the words shall not in Regulation 2. This means that the provision is seeking to restrict a person from doing something. 1 goes on to say what that prohibited thing is. What it prohibits, in clear terms, we say, is that a person who attends a gathering with more than 10 people. 2 articulates a caveat to the prohibition in 1. That is, a person can attend a religious gathering in excess of 10 people, but only if the gathering complies with the guidelines. That is a mandatory precondition. And that is because the phrase used is provided that. And on a plain and literal reading of the wording of the words provided that in the context of that section, it establishes that a person can only attend the gathering in excess of 10 persons if that gathering complies with the guidance or the guidelines. And that is the context in which the word contravenes in subsection 3 operates. The contravention is directly linked, as it were, to the words provided that there is compliance with the guidelines in 2A.
Mr. Ramlogan, in Regulation 2.2a, at the second last line, where it speaks about they comply, is that they a reference to each of the persons who are there?
Well, that's an interesting question. I think it could be read as applying to both the person who may be hosting the event, and it could also be read as applying to persons that are in attendance.
Yes. Because it must be the persons at the religious event.
Well, I read it, the they, as referring back to the services or gatherings. It's the services or gatherings that have to comply.
Ah.
But if they don't, then any person attending.
But the service or gathering wouldn't itself couldn't comply. It's just an aggregation of people.
Well, I know.
It must be the persons at the gathering.
I think
So
it's kind of.
it seems that anyone who is at that gathering may find themselves in trouble because someone else at that gathering is behaving in a way that doesn't comply.
Well, this is part of the uncertainty and inherent ambiguity, because your appellant before this board, Mr. Satyanand Maharaj, is a Hindu priest who owns and operates an ashram. And he interpreted this regulation as applying to him in his capacity as the owner and operator of the ashram, where devotional services are conducted for members of his congregation. So there is a bifurcated way. There are two ways to look at this. It may very well apply to the person who's hosting the event to ensure that he doesn't exceed the number of persons, and if he does, that he complies with the guidelines. And I'll come to that in a bit, because the guidelines themselves, when you look at it, it may be conducive to that interpretation. But equally, because if you're hosting it, you have to have hand sanitizers and a host of other things, and the guidelines speak to the host of the event. But equally, when one reads it, it must surely be applicable, as my Lord has pointed out, to the persons in attendance as well. But that's part of the ambiguity and lack of certainty as a preliminary point. But if I can continue, bearing that in mind, I will come back to it when we go to the actual guidelines. We say what the provision offers in one hand, it claws back with the other, i.e. the caveat to the prohibition itself is contingent upon compliance with the guidelines. And 2 is not, therefore, a simple caveat which removes from the person the prospect of criminal liability if the gathering exceeds 10 people. And all of this, my lords, my lady, occurs against the reality that the intention of the rule is to create a criminal offence, as the wording of section subregulation 3 clearly states. And in the final analysis, we say this provision is not permissive. It is restrictive by reference to compliance with the guidelines. And we say, therefore, the Court of Appeal erred in finding that the words provided that created, in effect, a permissive proviso, which did not, in fact, amount to a prohibition. Insofar as there is ambiguity at all on this issue, namely whether on a literal construction, the provision embraces a contravention of the guidelines, that we say that that serves to demonstrate the inherent ambiguity and uncertainty in the provision. The fact that even the High Court judge and the Court of Appeal arrived at diametrically opposed interpretations and conclusions on the meaning and the scope of this regulation tells us that there is an inherent sense of ambiguity and lack of certainty that is underscored, and far less for a layperson who is meant to be governed by such a regulation. Allows if I take you next to the judgment of the High Court judge, which and I ask you to turn to page 198. At page 198, paragraph 10, you will see these were the preliminary issues that were certified because
I'm sorry, page 198 in which bundle?
Oh, the Suraj bundle, my lord. Unless I say otherwise, I'm using the Suraj bundle.
Okay.
At page 198 of Suraj, at paragraph 10 of the High Court judgment, this matter was deemed fit for urgent expedited hearing, and this is what the judge certified. He says, in respect of Satyanand Maharaj, whether regulations 2.2 and 2.3 are unconstitutional, illegal, null and void, and no legal effect, and whether the regulations have breached the claimant's constitutional rights under A, B, or H, and any consequential matters arising therefrom, except damages. So that's why I mentioned before that if it comes to that, that's a question to be remitted for assessment by the courts below. I next ask you to turn to page 257.
But just before we leave this, there's no complaint in terms of the certified issues in relation to regulation 2.1, but it clearly wasn't the minister's intention that there should be an absolute prohibition in terms of regulation 2.1.
No. The issue focused, my lord, on the on 2.2.
Yes, what I'm meaning is, if you knock out regulation 2.2, or I suppose 2.3 is perhaps the saviour.
But my lord, I think 2.3.
Yes, I see. Yes, because 2.3 is the provision that creates the offence.
Yes, indeed, my lord. Indeed, my lord has got it. So if I ask you next to page 257, please, my lord. We will see. I wanted to show you that, as a matter of administrative housekeeping, that the judgment in Maharaj, because it's a single composite judgment, begins at paragraph 107. And you will see he says, in respect of the second claim, Pandit Maharaj's issue on the regulations goes to how his right to practice his religion has been affected, particularly by the gathering provisions. And I asked you then, I take you lower down to the top of page 259, because in the context of Satyanand Maharaj, it's interesting what the judge said at 259 at the top. This is part of paragraph 110, paragraph 1110, and he says at the top of page 259, he says, in my view, there ought really to be no objection in principle to some form of parliamentary scrutiny to regulations being made, which, even if justifiable, impact on the freedom of citizens. There is no specific relief sought about modifications to the ordinance, as the ordinance was not challenged, and therefore the court cannot make any such order. I would, however, urge the Attorney General to consider at minimum some form of appropriate parliamentary scrutiny for regulations made by the executive where normal everyday freedoms are affected, as has occurred here. I would note that both Williams and Keebline cases above speak about the legislature being involved in lawmaking. lower down at paragraph 111, 6 lines from the bottom of the page, he says, this decision should therefore not be taken as encouragement to expand areas of law where regulations made by the executive restrict rights and freedoms of individuals without parliamentary scrutiny or without considering whether a special majority is needed. It cannot become the norm for laws, in my view, especially with significant penalties attached, to be made without any parliamentary input. Now, of course, although this comes in the section of the judgment that deals with Satyanand Maharaj, it harkens back with equal relevance to the Suraj appeal as well. But the point is, the uncertainty and ambiguity, if it were put before the Parliament, it may or may not have been resolved, at that stage, and maybe that's what the judge might be alluding to. And can I just take you next to page 259? To page 263. If I take you, to page 260 first. At page 260, paragraph 113, he says the critical issue, however, as I see it, is can a penalty be imposed in respect of guidelines? A penalty can be imposed for an offence. Conduct can be prohibited by a regulation, but those regulations have to be incorporated into law by the process prescribed. To the extent that the guidelines were not incorporated as law, they cannot be subject to a criminal penalty. In considering these guidelines, it is difficult to say whether some of the provisions can be subject to criminal conduct. The language appears to be voluntary in some instances, referring to should, ensure, encourage, endorse, advise, discourage, adapt, consider. There are examples of suggestions being made, such as, where possible, set up hand sanitizer dispensers, provide an adequate supply of 60% alcohol-based hand sanitizer, encourage persons where possible, discourage non-essential physical gatherings, and it would be ideal to have. These dictates are not easily capable of being construed in a way to allow for certainty that they are offences. An offence creating statute must specifically state the conduct which leads to criminal liability in mandatory terms. Criminal statutes must be expressed as a command. A person cannot be put in peril of being prosecuted by language which suggests a mere recommendation. And then lower down at page 262 at paragraph 120, he says, further, while I accept the defendant's contention that there is a precedent in other jurisdictions for incorporation of documents into a statute, the criminalizing of conduct by reference to guidelines is, in my view, unsustainable in these circumstances. This is specifically in reference to there being no clear identification of which provisions of the guidelines will lead to criminal sanction. That in itself puts someone in peril of being brought to court to answer an uncertain offence. My Lord, if I take you next to the Court of Appeal's judgment at page 515.
So are you taking both these points, that the regulation is objectionable, firstly because it is lacking because the offence created is lacking in certainty and therefore offends against a variety of the rights protected by Section 4 of the Constitution. But in addition, because the offence is defined by reference to guidelines which are not themselves law. Those are two distinct.
Indeed, my Lord, yes. The short answer is yes, we are. We rest on those two, on both grounds, my Lord. And I will come to that in a bit. But yes, short answer is yes, my Lord, we do.
Yeah.
If I can take you to page 515 to show you how this matter was dealt with in the Court of Appeal at 515, if we back up to the bottom of 514, you will see that regulation 23, which is the material regulation, it's set out in a truncated manner because they've set out regulation 2.1 A. They've omitted, I suspect, B and C. And then at 141, this is the court's ruling. It says, the offence creating regulation appears, therefore, at sub-regulation 2.3. This imposes penalties of a fine and imprisonment for the contravention of sub-regulation 2.1, which prohibits gatherings in excess of 10 persons. However, so they've restricted it, the operation, the offence clause, they've restricted it to 2.1. And they've said that sub-regulation 2.1 does not contain an absolute prohibition. The legislator provided an exception to the general prohibition by including a permissive provision, which enables ecclesiastical congregations to exceed the stipulated number of 10, provided they comply with the guidelines. Neither sub-regulations 2.2 nor 2.3 speak to a breach of the guidelines. Rather, reference to the guidelines are in the nature of a proviso and take the conduct prescribed therein out of the ambit of the more restrictive general provision. They reduce, not expand, the reach of the prohibition by permitting behavior that would otherwise be criminalized. At paragraph 145, at the bottom of page 517, they fault the trial judge by saying that his finding was based on an incorrect premise, and that is that the breach of the guidelines was rendered a criminal offense. And so that's the divergence of judicial opinion between the trial judge and the Court of Appeal. We say the trial judge was plainly right, because on a plain and literal reading of the regulation, there's no justification for limiting it to subsection 1 and excluding from its scope an operation, subsection 2, which deals with
Well, let us say, Mr. Ramlogan, that there was a breach of the guidelines and therefore subsection 2 didn't apply to extend the numbers. The charge that would be made against the person would be under subsection 1, that they were within a gathering of more than 5 people or 10 people without reasonable justification. So, the question really is there uncertainty in the charge of being in a gathering of more than 10 people without reasonable justification? And if you're allowed to advance the reasonable justification defence at that stage, then some of the uncertainties in the guidelines may be dealt with by an assessment of whether the justification is reasonable.
I accept that, my lord, but the problem is that we can't ignore sub-regulation 2, which is a discrete provision, which speaks to persons gathering for specific purposes in excess of 10 persons. So you're allowed to do that, but only on the condition that you comply with the guidelines. And the wording of subsection 3 is that a person who contravenes this regulation. It would have been easy for the draftsman to say a person who contravenes regulation 2A or regulation 2.1, sorry, commits an offence. But that's not what the drafting says. And one's got to take it as its literal interpretation. So 3, which creates the offence, clearly, by not specifying regulation 2.1, must be taken to apply to regulation 2.1 and as well regulation 2.2. And that's our submission. Now, it's worth noting as well that when it comes to 2.2, 2.2 is discrete and separate, because if you had a wedding, it's not likely to be a public place to which the public can have access and attend. Not everyone can crash into a wedding in Trinidad. A christening as well would likely to be held at home or in your church with your close friends and family invited. So that the public place which applies to, 2.2 is a different provision, and one that we say it's possible to compartmentalize and take on its own. You know, and therefore, if you're having a wedding or a christening at your home, you can exceed 10 persons, but only if you comply with the guidelines. And if you allow, and it begs the question, if you're allowed to have more than 10 persons and you can not comply with the guidelines and there's no sanction for it in the context of a pandemic, then that really renders suspect, you know, the entire regulation. I mean, the mischief that it intends to address plainly is to regulate human in a numerical with a numerical restriction, and by reference to compliance with the guidelines on the pain of a criminal offence.
Would the person charged with a criminal offence, because the guidelines hadn't been complied with and there were more than 10 people in the gathering, would that person still be able to assert a reasonable justification?
Well, my lord, that would be a fact-dependent exercise.
No, it wouldn't. It's a legal question.
Yes.
Would the law allow him to say, or her to say, notwithstanding that this religious gathering didn't comply with the guidelines, this was nothing to do with me, there was a reasonable justification, someone else did something which was unwise, I'd done everything I could to make the gathering compliant, and so I had a reasonable justification for being in that public place where more than 10 people were gathered together?
Yeah, well, my lord, as my junior Miss O'Reilly reminded me during the break, we've got to focus on the middle stump here. The middle stump here is the definition of the offence. We're not on the question of what the defence is. Respectfully, the issue is the offence itself devoid of ambiguity and sufficiently and clearly and precisely defined so that the average man and woman on the equivalent of the Clapham omnibus will know what is prescribed and prohibited and what is permitted. And that's the issue. Now, the reasonable justification goes to the question of the defense that you advance after you've been charged. But the issue here is the charge, the offense itself, is that sufficiently clear to regulate, to allow the average Trinidadian to regulate the conduct of his daily affairs so that he will know and reasonably foresee criminal consequences attaching to, what is permissible and what is not. And we say it falls on that sword.
But are you saying it's not simply the guidelines point, that there's a lack of clarity in the way that Section 2.1, Regulation 2.1 and 2.2 are set out?
Indeed.
It's not clear whether the reasonable justification defence is only in 1 and not in 2, whether the requirement that it's a public place applies to religious funerals and weddings, or whether they're caught regardless of whether they're in a public place and regardless of whether there's a reasonable justification. Presumably during the period specified in Regulation 16, one would have thought that does apply to both 1 and 2. But as far the way that they've been set out means it's not clear whether 2 is just a caveat to 1 or whether it's a freestanding offence.
Yes, that's correct. I mean, that's why we say there's a sense of inherent ambiguity. It's not just in terms of the substantive content, it's structural as well. I mean, even the way the regulation is structured creates ambiguity because you're right. I mean, one is not clear. It's not readily apparent from reading it to us as lawyers and judges as to what precisely is covered by the offence-creating provision in sub-regulation 3. And if we can't be clear, then, our fortiori, the average layperson wouldn't have a clue.
I wonder whether if you were someone that went along to, let's say, a religious service, and you said, well, I believed that every effort was going to be made to comply with the guidelines, whether you wouldn't be able to say, whether or not that proved to be the case, I had reasonable justification for being in a public place with more than 10 people.
Yeah, well, my lord, the problem with that is this, my lord. What about the appellant? So if the appellant is conducting a religious service and he's sitting on the, the priestly throne, as it were, what's called a sinasan for Hindus, and if he's sitting on the sinasan and there are 10 people there, and whilst he's in the middle of meditating and chanting his Hindu mantras, and the 11th person walks in through the door, is he, because there's the guidelines now kicking, is he in breach as the host and the owner and operator of the ashram and as the host of the spiritual ecclesiastical Hindu service? Is he in breach?
Forgive me, why wouldn't he be able to say, I've put in place, so far as I reasonably think I can, all the measures that would secure compliance of the meeting with the guidelines. If thereafter something happens which I couldn't have predicted or taken measures to deal with,
yes, of course. Yes.
Nonetheless, I was in a public place with a meeting of more than 10 with reasonable justification.
Yeah, well, my lord, one of the points made in the High Court judgment by the learned judge is, look, we've got to look at this from the perspective not just of the citizenry, but the police. Given the ambiguities, and when we come to the guidelines, which I'd like to turn to shortly, you will see that how are the police meant to interpret and enforce the law? And how are the police, what is an overzealous police officer to do when he walks in? The reasonable justification argument is a defense to the charge, but the decision on the question of whether you lay a charge or not, police are not entitled to interrogate the defense at that stage. They must act on a prima facie basis of what they see when they walk into the ashram, or what they see when they walk into the christening or the wedding. So the short answer is yes, people may have a good defense at times, depending on the factual situation, but that is not an answer. It's neither an answer nor a cure to a defect, a patent defect and deficiency in the definition, the lack of clarity in the definition of the offence.
Just looking at the structure of this, I wonder whether one can almost regard sub-regulation 2 as, if you like, fleshing out in particular circumstances what might count as a reasonable justification. So reasonable justification gives you a certain idea. I don't think you're saying that that is inherently uncertain for the purposes of the standard of law. Might it not be said, well, that it may be imperfect what is said in the guidelines, but it gives you, if anything, a more concrete idea of what is likely to count as a reasonable justification?
The problem with that, my lord, is that when one goes to the guidelines, given the wording and the phraseology in the guidelines, it doesn't remove the uncertainty and lack of clarity. It actually makes it worse and compounds the problem. And on that note, can I just?
I think it's also difficult. Then what you're doing, in effect, is relying on reasonable justification to effectively insert a best endeavours caveat to the compliance with the guidelines. So you're reading reasonable justification as if 2A said, provided that they use reasonable endeavours to comply with the guidelines, which is not what it says. But I'm not sure that a reasonable justification defence is usually regarded as use best endeavours to comply, rather than a reasonable justification for not complying. I think those are they may be two different concepts.
Yeah.
Yeah. You see, it's precisely because of the number of legitimate and reasonable interpretations that one can place on this simple regulation, that it's unfair to subject a citizen to it, because it really does lend itself to a certain amount of arbitrariness, which is an absence of clarity, which, as was said in the Mercer Island shipping case by Lord Diplock, is destructive of the rule of law. Can I take you to the guidelines, if I may, conscious of the time constraints we're under, at page 4337, my lord, my lords, my lady. I'll just do a quick troll. I know that the board will, of course, read it in due course, but it starts at 4337, and you will see it at paragraph 4, which is on the page at 4338. It's the responsibility of the heads of religious organizations to communicate these guidelines to their members or congregants via announcements, signs, bulletins, websites, social media, and so forth. Now, the point we make here is that the guidelines are not even in a schedule incorporated by express reference to the regulations. So the guidelines are an administrative document prepared by public servants, and it is detached from the actual regulation. Had it been put, for example, in a schedule to the regulation, one might say there is some basis to say it has acquired the force of law. But there we are. And it's up to the heads of the religious organizations to communicate these guidelines to their members. And the paragraph 2, we're told elderly persons should be given the option to attend services, preferably in the morning at 6 a.m. Should be given preferably early. As to how do we marry reasonable justification, even if it did apply to 2, in light of my Lady Rose's quite apt comments and observations earlier. If we go to sanitization of the facilities at 412, at number 4, we see the words, where possible, set up hand sanitizer dispensers at specific areas, where possible. I mean, that's very subjective, where possible. What I might view as a possibility, you may view as an impossibility. Personal hygiene, 4.13, number 2, provide an adequate supply of 60% alcohol-based hand sanitizer or hand washing facilities, soap and running water for use after the service. It would be ideal to have easy open close taps, or pedal or actuated or hands-free taps. It will be ideal. So if you fall short of the ideal, have you breached the guidelines or not? If you use an alcohol-based sanitizer that's less than 60%, are you breaching it or not? And how is the police officer to determine that? Does he seize the hand sanitizer and take it to a chemist's lab? And then at 5, number 5, endorse and encourage proper mask etiquette when entering and within the establishment. Encourage persons to bring their personal rugs, coverings, and fabric to worship on the floor. Encourage persons, where possible, to bring their own worship materials. Endorse and encourage proper cough and sneeze etiquette within the establishment with a tissue or use of the inside of the elbow. And I scroll down now to 4.15, physical distancing. Number 6, discourage non-essential physical gatherings and organize virtual gatherings through live streaming, television, radio, and social media. Some churches are rich, some churches are poor. Is it that it's a reasonable, justifiable defense to say we can't afford to have live streaming? I don't know. At 4.16, sharing of worship materials, adapt worship practices, encourage new ways of reverence, consider temporarily limiting the sharing of frequently touched objects, encouraging congregants to bring their own such items if possible. Number 6, ensure that meals and religious ceremonial foods are individually prepackaged. And 7, ensure that ensure setting up no-touch method to collect contributions, where stationary boxes can be used, that facilitates or encourages social distancing. 4.17, use of music. Number 2, ensure that there are limited singers on the podium or platform, which is the altar area. Well, how many are limited singers? 1, 2, 5? Wouldn't that also be a relative to what the normal size of your choir is? A choir of 20, limited amount might be 10 or 5. Highly recommended, solo performers only. Well, if it's highly recommended, does that mean I can ignore it and have a duet? Number 3, ensure that microphones and musical instruments are not shared and must be sanitized after each use or service. 4.18, consider how technology can be used. Consider partnering with other organizations, etc., etc.
Now, Mr. Ramlogan, you are running very short of time.
Yes, my lord.
You've set out submissions in your case on most of the points that have occurred to us. But could I ask you to address one point?
Certainly.
It strikes me you're challenging the regulations under the Constitution, and that's really so that your client can obtain damages for a violation of his constitutional rights. It might be said that if your points are good points, then the regulations are simply ultra vires and could be set aside without needing to rely on the Constitution.
Well, my lord, that's true. But the question would be whether the ultra vires regulation impacted on the exercise of one's fundamental rights. And in this case, we say it plainly did, because our client was subjected to the strictures of a regulation that was null and void and ab initio. The constitutional rights that are involved would obviously be, 1, the right of protection of the law, which in the Jamaicans for Justice case, Lady Hale accepted the jurisprudence of the Caribbean Court of Justice, arbitrariness, irrationality, fundamental unfairness. It would be a breach of the right to protection of law in our submission to, bearing in mind the words of section 14, which is, there are 3 categories. 1 is past violation of fundamental rights, present ongoing violations or threatened violations, and of course likely to violate, which is futuristic.
Yes.
So that
what I'm wondering is, Mr. Maharaj chose to respond to the regulations by bringing an application under section 14 of the Constitution. He could simply have brought an application for judicial review under the common law. Well, that's the point I'm raising with you, because it might be said that he could have found himself a remedy for any concern he might have had about his constitutional rights, without actually having to rely on the Constitution at all.
Well, that's certain. You may note, my lord, that we did bring this claim as a hybrid claim for judicial review and constitutional relief. The reason we, at the case management stage, the judge, the trial judge was elevated soon after he delivered judgment in this matter to the Court of Appeal, and he had already received notification, I believe, and he had indicated to us that, look, he will deal with the issues, the constitutional issues, and given the supremacy of the Constitution, the case management orders were made so that we dealt with it on a constitutional basis.
Thank you.
Having regard to the supremacy of the Constitution. Now, my lord, I accept entirely it would have been possible to do that in a judicial review. Hence the reason we brought that claim. But even then, the question is, that is not an answer to whether an ultra vires law which prohibits one in a way that affects the exercise of their fundamental rights.
Yes.
We've got to confront that question. We can't sidestep it. the regulation here impacted on the right to freedom of religious belief, practice, and observance. It impacted on the right to protection of the law, which protects you from arbitrariness.
I understand your position. That's very helpful. Thank you.
Thank you, my Lord. My Lord, with that in mind, can I just briefly summarize the submissions with respect to the guidelines? The first point is we say this. The guidelines formed no part of the regulations. So a person looking at the rule itself does not know and cannot know from the regulations how a gathering they attend may expose them to criminal sanction.
Yep.
The guidelines did not form part of the do not form part of the regulations leaves them with no apparent force of law on their own beyond the mere fact that the government published them, and as the opening paragraph state, heads of religious organizations are meant to communicate them to their membership. And bearing in mind the guidelines constitute an administrative document drawn up by public servants, is it that if it has the force of law, does it mean that this law can be amended by public servants administratively when they amend the guidelines? Because the guidelines are in fact reviewed and amended from time to time, is that permissible? The regulations themselves.
Mr. Ramlogan, can I just ask you a question about that? So are you submitting that in order to qualify as law, a regulation made under the Public Health Ordinance powers would have to be published in the Gazette under, I think it's section 132,
Yes, Lord.
and so that the full text of the law that is going to be applied has to appear in the Gazette published in that way?
Correct, my Lord, yes.
And can I check then, that seems to be a submission that excludes the possibility of regulations incorporating by reference something which is not published in the Gazette. Is that your position?
We say that it certainly excludes reference to an administrative document prepared by public officers, which is published on the ministry's website and liable to be changed by the public officers without reference to the process by which the regulation is made in accordance with the Public Health Ordinance.
Yes, thank you.
Right. My Lord, so we say that the regulations themselves did not define any criminal conduct. That is significant both in terms of certainty, but also accessibility, because insofar as the provision purports to be a criminal law at all, it simply fails to define in any way the conduct which is caught by it. The guidelines are just that. They're guidelines, they contain recommendations, suggestions, encouragement, and all manner of advice that applies to those organizing and participating in collective religious worship. The content of these guidelines is fundamentally inconsistent with what would on settled principles be recognized as bearing sufficient certainty to found a criminal offense. They contain statements like self-regulation is recommended, for example. And the purported criminal offense is inherently vague, woefully uncertain in its application, incapable of permitting sufficient regulation of a person's conduct so as to avoid penal sanction, and was open to abuse and arbitrary application. They frequently make little more than strongly worded suggestions with the use of words like encourage and endorse, which we've seen, and the language itself is incapable and incompatible with bearing a sufficient certainty to describe conduct which has been lawfully criminalized by the regulations. My Lords, I think given the time constraints, we will in fact rest at this stage, and I would just say a word on the relief. We say that if there are three options, the court can grant declaratory relief. The court must then consider whether it impacted on the exercise of fundamental rights. We say it did, and we ask that the court grant a appropriate declaratory relief and remit the question of damages to be assessed by the High Court. Those are our submissions, my lords.
Mr. Ramlogan, just before you close, in relation to the relief that you are seeking, if one looks at Regulation 2, which is page 1429,
yes,
as I understand it, you're seeking a declaration and other forms of relief on the basis that Regulation 2.2 and Regulation 2.3 are void. Now, Regulation 2.3 covers also Regulation 2.1, and you do not have a claim that Regulation 2.1 is void.
No, I agree, my lord. I agree. So,
And yet the relief that you're seeking for a declaration or other form of relief to the effect that Regulation 2.3 is void would deprive Regulation 2.1 of effect in the criminal law, because it's 2.3 that actually creates the offence. And I just wondered whether you were able to explain to us the interrelationship between leaving 2.1 unaffected, but the relief that you seek in relation to 2.3.
Can I answer that, my lord, by asking you to turn to page 266? At page 266, you'll find the declaration granted by the High Court, and you will see how the judge phrased it, to taking that into account, I think. He says it is declared that the relevant public health regulation are unlawful to the extent only that they make a breach of the guidelines for places of worship made by the Ministry of Health a criminal offence.
But if you leave Regulation 2.1 in place, on the face of it, anyone who attends a meeting with more than 10 people is committing an offence unless they have a reasonable justification. So I'm not quite sure what that declaration actually achieves.
Well, my lord, I take the point. I take the point. I mean, the inherent uncertainty is not limited to sub-regulation 2. There is uncertainty, as I said before, in terms of both the contents and structure of the regulation. And it obviously gives rise to that problem as well. It may very well be, my lord, that the appropriate relief may have to be all-encompassing, or we can find a formulation that the board is comfortable with in terms of compartmentalizing sub-regulation.
All right. So, I'm sorry.
Well, standing up for the judge, it might be said that if you simply, well, first of all, it might be said that the court should not declare the regulations, either Regulation 2 as a whole, or indeed 3, which is the provision, paragraph 3, which creates the offence, void, because that could affect dozens, possibly hundreds of cases which have already been dealt with, or cases where there is no doubt that an offence, on any view, was committed. And equally, it might be said that the court shouldn't leave simply Regulation 2.1 standing, because it was never the minister's intention that paragraph alone should be enforced, and therefore the paragraph 1 isn't truly severable from 2 and 3 in the way that a declaration of that kind would require. And that what the judge has done is to focus purely on offences in respect of places of worship, and in particular the impact of paragraph 2.2, Regulation 2.2a, which is the one that's problematical. And he's effectively found that declared the regulations are unlawful to only to the extent that these proceedings are concerned with, which is making a breach of, well, you might express it slightly differently. You might say making the commission of an offence in respect of places of worship dependent on a breach of the guidelines for places of worship. I mean, you could. I wonder. You could alter the wording slightly, but.
Well, I wonder whether the effect of what the judge says is simply to strike down the proviso in 2A, so one is left with that.
No, I don't think so. I think his intention is to, because he can't have had the intention, I don't imagine, of making it unlawful for religious services to take place at all with more than 10 people present.
Yes, no, the words from provided that.
But he can't have had the intention of having a free-for-all in every place of worship.
No.
That would be the effect of taking out the proviso.
Yes.
Perhaps it might be helpful to note, my lords, that after judgment was delivered, all subsequent regulations removed that bit which says that they'd inserted a provision to say that breach of the... I'd ask that you be passed the latest version of the regulations this morning. I apologize for the lateness of it, but I wanted to show you what the present situation is, because it might be relevant to this point. I don't know if my lords have...
I'm not sure if we have that. What we got this morning's latest bulletin was the bundle containing the chronology that Mr. Knox took us through, and extracts from the Wooding Commission on the Constitution.
Well, can I just read what it says? After the judgment of the High Court, it's the Minister of Health may, for the purpose of the operation of these regulations, issue such guidelines as he may deem necessary, and breach of such guidelines shall not constitute an offence. So after the High Court judgment, the state, the respondent in all the various incarnations of the regulations, which we've been living with now for the better part of over 2 years, they ceased to make breach of the guidelines a criminal offence, and that was expressly provided for. So that I thought that that was an implicit recognition and acceptance on the part of the respondents about the correctness of the judgment in the High Court, but then they appealed.
Yes. Yes, thank you, Mr. Ramlogan.
I'm obliged, my lord. Thank you very much.
Yes, Mr. Rowe.
Thank you, my lord. Perhaps I should start with the proper construction of the regulation itself. So back to page 1429. I agree there's perhaps room for some debate as to exactly how it all fits together, but in my submission it's ultimately relatively plain. Paragraph 2, or Regulation 2 rather, creates the general offence. Regulation 2.1, that's to say, creates the general offence. Person shall not, without reasonable justification, be found in any public place where the number of persons gathered at any time exceeds 10, or do various other things in B and C. That the words "without reasonable justification" have been referred to once or twice in passing as constituting a defence. It may not matter, but I'm not sure that it's necessarily right to say it's a defence as opposed to an ingredient of the offence, that you don't have reasonable justification. And yet again, I'm afraid in this case it's thrown up an issue which is not in authority in the bundle as far as I can tell, but there are authorities about precisely this point. One of them is, for example, an English case called Charles, Queen against Charles, reported in the Weekly Law Reports in 2010, about antisocial behaviour orders, which where there's an offence of breaching one without a reasonable excuse.
Yes, this is 2010, 1 weekly.
2010, 1 weeklies, 644. And I think, from memory, I think the law in relation to criminal damage, for example, the law is similar, without lawful excuse. If one recalls that.
I think it was also a point in Ziegler.
Yeah, lawful excuse.
Yes.
Yeah.
Yes, and I think we accepted it as an ingredient of the offence.
Yeah.
The prosecution would have to prove.
Blocking the Queen's highway.
Yes.
Without lawful excuse.
Yes. It's why, in the criminal damage context, it's why, I think from recollection, it's why the judge dealing with the people in Bristol had to direct them that it was for the Crown to prove that they had no lawful excuse when they'd said they had lawful excuses for destroying the statue. So it is, I think, well, we can check the point if need be, but it appears to be a part of the offence rather than a defence. But in any event, or rather the absence of the reasonable justification appears to be part of the offence, so it's for the Crown to prove, or the State here to prove, the lack of reasonable justification. And those, if one just stopped reading at Regulation 2.1, then it's perfectly clear, whether one likes it or not, what the law is, and there's no real cause for uncertainty at all. As of the date of this set of regulations, the way in which you avoid liability to the criminal law is to make sure you're not in a public place where the number of persons gathered at any time exceeds 10. and that's that. And that's important in terms of the context, I submit, because as the Court of Appeal emphasised, that fact does mean that you can be sure as to how to behave if you wish to avoid infringing Regulation 2. You keep away from anywhere where there are more than 10 people gathered together. But 2.2 then goes on to deal with, in A, the religious or ecclesiastical services, etc. The wording of it grammatically does appear to be, as I think Lady Rose put it, I would submit, that the they, the pronoun they in that context, stands in for services or other religious gatherings. I say that because partly because the rest of the style of the document is to talk in the singular about a person not doing various things, not only in Regulation 2 but elsewhere. And they isn't necessarily here a non-sexist synonym for a more old-fashioned form of drafting of he, because we can see the word he crops up from time to time elsewhere in the regulation. So it looks as if the grammatical, what would appear to be the grammatical construction is the right one. That is to say, the services or other religious gatherings comply with. In other words, the limit of persons at religious or ecclesiastical services, etc., may exceed 10, provided that the services or other religious gatherings comply with the guidelines for places of worship issued by the Ministry of Health. It's true to say that the guidelines themselves, of course, are not law, and they were not published in the Gazette. But they're not inaccessible, in my submission, when we've got them in the record for the board to read. They were available on the ministry's website, and so of the 2 points that our learned friends take, the discrete point that it's not acceptable at all to have this arrangement whereby the law incorporates something from outside what might be called black letter law. Is a bad point in my respectful submission.
Well, I wonder if it's quite so simple. The regulation contains within it a requirement that, the Act rather, Section 105, contains a requirement that regulations made under that section have to be published in the Gazette.
That's true, my lord. That's right. But we would draw the distinction between the regulation itself, which was published in the Gazette, and something to which the regulation refers, which was not. And it's not, as we've sought to make clear in our printed case, it's not entirely without precedent for a legislator to say that some document which is not itself legislation shall nevertheless have potentially an operative role in deciding whether somebody is or is not guilty of an offence. And if I can just remind the board of that, this is in our printed case, where we cite what is said in the Motor Vehicles and Road Traffic Act. It's page 4472 in our printed case, paragraph 72. And it's the Highway Code, a failure on the part of any person to observe any provision of the Highway Code. There's an equivalent provision in the United Kingdom as well.
Yeah, that's
Probably where it comes from.
I'm serious. I thought that there was a particular provision in the relevant act that gave the Highway Code's particular status, which
yes, that's the provision that we set out in our case. That's actually a quotation from the Motor Vehicles and Road Traffic Act.
Right, but that's not our case here. I mean, I just wonder whether it might not be said that Section 132 of the ordinance, so this is page 1310, is really quite specific about what you need to do if you want regulations made to qualify as law. And it then goes on, so you have to publish them in the Royal Gazette, and it says, and when so published shall thenceforth have the same effect and operation as if they are enacted by and form part of this ordinance. So, well, I was rather reading that as saying that if you want something to qualify as law and have the status it needs to have as law, you had to put the text of what you wanted as law in the Royal Gazette.
Well, I think I can quarrel with that as a paraphrase of what Section 132 says in the ordinance. The question, I suppose, is whether that being so, it's permissible to adopt the approach that the Minister has adopted, qua secondary legislator.
Well, I'm putting it to you that perhaps it indicates it's not permissible to do it.
Well, it depends upon what one means, I suppose, by regulations. If my submission, and the reason I refer to the Highway Code, is to illustrate the point that one can have something which can properly constitute law, which, by its terms, incorporates another document which is not published formally in quite the same way that law is published formally. And one sees something similar in practice, well, conceptually similar perhaps, I would say, in practice. Very often, whenever a piece of black letter law says that such and such a standard must be followed. I mean, it's a closely connected point to our overall point about the alleged lack of certainty of these regulations, because as we say in our printed case, the law generally is full of examples of the question of whether somebody has acted lawfully or unlawfully for the purposes of criminal law, potentially punishable, being dependent upon whether they have met some relatively broadly expressed standard of acceptable conduct. And you see that in we give the example of the hazard, I've forgotten the exact wording, substances hazardous to health, for example, where there's an obligation to carry out a suitable and sufficient assessment. Now that in practice will immediately bring into play questions of fact as to whether or not, on the particular facts of the case, the defendant, before embarking upon whatever it was, decanting some chemical in some factory or whatever, complied with a reasonable standard of behaviour, which in turn will bring in...
Forgive me for cutting across.
Not at all.
I'm not sure if we're not talking about different things. I was focusing on what needs to be done for something to count as law at all, according to the standards set up by the ordinance.
Yes.
And you seem to be making a point that, well, quite often laws are expressed in relatively vague or general terms, which I fully accept.
Yes, but I'm going a bit further than just saying that much, which is perhaps the trite thing to say. The point is that quite often the law, in practice, is likely to incorporate into it other standards. If one's considering the question of the person in the factory, the person in the factory where it all goes wrong and somebody gets terribly hurt, the reality is going to be in the trial that you're going to have evidence about what the relevant standards were. There's bound to be evidence before the judge to say, well, actually the relevant guidelines produced by the Health and Safety Executive, for example, say you must do it in this way and not that way. It's not a precise analogy, I would accept, with what we have here, where there is black letter secondary legislation, which in turn incorporates...
What you're talking about is different kinds of evidence that show whether someone has been negligent or failed to come up to some particular standard or not, which is really what the Highway Code reference is saying. It's not saying it's a criminal offence to breach the Highway Code. It's saying that when you're looking at various traffic offences, it's relevant to consider whether, when someone's accused of driving without due care and attention, for example, whether they've failed or comply with the Highway Code or not. But that's not quite what we've got here, I don't think.
I accept this. I couldn't find an exact analogy, I accept that, to the present regulation, which in black letter terms says, here is an exception to the basic rule. And the exception to the basic rule is that you can do what the basic rule doesn't let you do, as long as the event at which you are present is an event complying with the guidelines. And I agree, I couldn't find an exact analogy for that, but it's not a million miles away in my submission, and it's not. And I submit that it's neither objectionable as a matter of substance nor as a matter of form if one is focusing on the way in which here the ordinance talks about the requirement for publication, because once one accepts that one can have black letter law which necessarily imports into the court's task of deciding whether it's been complied with or not reference to some other standards, once one accepts that, then that law is black letter law. It is the regulation. And so in terms of section 132, this is a regulation which has properly been published. Of course, if you construe it differently and say that the regulation for these purposes consists of what we see on page 1429 plus the guidance, then of course I'm stuck, because I accept the guidance wasn't published in the Gazette.
So I'm looking at section 132 again. Why doesn't one draw the conclusion the guidance does not have the same effect and operation as if enacted by and form part of this ordinance? Well, i.e. is not law.
The guidance itself does not purport to be law does not purport to be law in the sense of creating an offence. No one can be charged with breaching a term of the guidance. The point is that in deciding whether somebody is guilty of a breach of the regulation, the fact that the event at which they were attending was one that complied with the guidance brings into play 2.2, and to that extent disapplies the black letter rule in 2.1 that the top number of people that can be there is 10. But that doesn't mean that it falls foul of section 132, because section 132 applies to the regulation. And my point is simply that here's the regulation, it's been published in the Gazette, and the fact that it offers this alternative way, as it were, of complying with, or this exception to the 10-person rule by reference to the guidelines, doesn't detract from the fact that the regulation itself has been published in the Gazette. So, my lord and my lady, I mean, in a sense, I probably covered most of the substantive points I wanted to make, but just seeking to do it systematically as I can so that I don't miss any of them. I do say that there's nothing ultimately in the technical point that relates to section 132 for those reasons. So far as the substance of it is concerned, the observation that my lord, your lordship made during the course of my learned friend submissions about whether this is actually a constitutional point at all, we respectfully endorse. Indeed, that's what we say in our printed case. There's really no need to resort to the Constitution here. There's no scope for it. If one accepts, and we've given the authority for doing so, it's Rimington, that the rule of sufficient certainty, if I can call it that, is a part of the common law, which it plainly is in my submission, then either this is sufficiently certain and it constitutes law, or it's not. And if it's not, then one doesn't need the Constitution to say, well, this was just ultra vires and not a law, because by implication, when the framer of the ordinance said that the minister could make regulations that were subject on the principle of legality to the implied proviso, they had to be regulations which themselves passed the test of sufficient certainty.
If I might say so, I slightly wonder about that, whether going under the Constitution and focusing on the constitutional complaint actually gives greater flexibility in working out what should happen with this regulation. So I go back to the point that I was raising with Mr. Ramlogan. The offence in the regulation is created by Regulation 2.3, which covers the whole of the regulation. So, I mean, it might be said that if one has to analyse matters in terms of whether the regulation is ultra vires, unless you can find a way of severing 2.3 as between 2.1 and 2.2, the effect could be that the whole regulation goes and is unlawful. Whereas if one focuses on the constitutional complaint, one can frame a declaration, as I think my lord was saying by reference to what the judge had done, which is much more precisely tailored to the wrong which is actually claimed on the part of Mr. Maharaj.
Well, I wonder, my lord, if that isn't rather to downplay the common law's ability to come up with remedies in pure public law situations. I mean, one sees, of course, the problem, because you can either say the whole thing's either ultra vires or unconstitutional, or both, if that's your conclusion. But of course, that chucks lots of other things out which are not the target of the litigation at all.
Right.
Or one can say, well, perhaps you try and cut off the proviso, but then that means that you could have as many people as you liked without complying with any guidelines as long as it was religious, which is effectively legislating for a different dispensation. And whichever way one cuts it, there's difficulty. So one can see that the court, if the court was impressed by this point, could frame a declaration perhaps along the lines of what the judge did, to the effect that here is the specific flaw in this way of doing things. Yeah. If that's what the court thinks. But I'm not sure I'd accept that that's something that only a court seized of a constitutional motion can do, and that a common law court couldn't do it.
Since this morning, I'll be cautious what I say without checking. But my recollection is that the board heard a case a little while ago where Lord Carnwath gave the opinion of the board in a case called Fishermen and Friends of the Sea.
I remember
to do with licensing of fishing in the South Pacific, where it was found that the system of licensing, which had been in operation for years, was ultra vires. But rather than quashing, the board took the view that it had a remedial discretion, and it granted, I think, a declaration so as effectively to avoid causing administrative chaos and give the government of whichever territory it was time to.
It was Trinidad and Tobago. It was I think it was my learned friend to my right against me, and he won, as I recall.
Yeah,
so yes, I mean, your lordship's right, and of course there is room for flexibility. So one could devise some form of remedy that didn't involve imperiling lots of other convictions that had nothing to do. I'm reminded by Mr. Hussain that was a judicial review case. So,
was there any evidence before the High Court as to how many people had actually been prosecuted or convicted for attending religious services which failed to comply with the guidelines?
Yeah, I don't think there was, but because I think this was done in anticipation. I mean, that's so it would. Thinking about the chronology at the time the matter was before the High Court, one wouldn't necessarily know in any event, because the wheels of criminal justice move rather more slowly than the wheels of constitutional justice. So, so I don't think the short answer is no. But, my Lord, before we quite get on to the question of remedy, I would still respectfully submit that actually we don't need to get to that point, because the law does pass the requirement of sufficient certainty, and I do place some weight, albeit I accept one has to be careful about this, but I place some weight on the Court of Appeal's observation that this is an exception to a general prohibition, and that's important, because of course the purpose of the rule of sufficient certainty is to ensure that people can obey the law, and the assumption being that most people will want to obey the law most of the time, so that they know they don't get caught out committing offences when they don't realise they're committing offences, and therefore they should be able to work out, if necessary, with professional help, if they're doing something that's a bit more elaborate, but whether or not what they're doing or what they're proposing to do infringes the law. And this is a case where there is a very clear way in which one can ensure that one doesn't infringe the law, namely not to attend any gathering where the number exceeds 10. I say one has to be a bit cautious about that, because of course the reason that people might want to attend a gathering exceeding 10 people might include attending a religious service, and one can't downplay.
Beyond that, Regulation 2.2 positively invites you to attend a religious service.
Well, that's perhaps also a fair point, my lord. Yes, I mean it is nevertheless, I submit, significant that this is a regime that's been carved out for a particular field of activity. So it is to that extent it's different from a provision which you or it's different from something which covers an area of life that you can't help engaging in.
Well, some people would say they can't help engaging in religious services.
Which is precisely, my lady, why I said one can't put too much weight on the point, because one has to recognise that there are far more powerful factors that impel people to go to church than impel them to go windsurfing or whatever it might be. So that's why I don't put that much emphasis on the point. But I say nevertheless it is a significant distinction. But in any event, I do rely simply generally on the point that the law does not require absolute certainty, and when one looks at the array of possibilities that there are in the law, there are those provisions. We cite one of them in our printed case. It's an obvious example, but you can't drive a car that's not licensed. That's absolutely clear, and there's really nothing by way of discretion. But one looks at the spectrum that runs between that and other offences like gross negligence manslaughter, for example, which really depend upon applying very broad tests of whether you took reasonable care in all the circumstances. This is actually towards the more precise end of the spectrum, if anything. And it's true, of course, that the guidelines are expressed to be guidelines. So they talk about things that you should do and things that are recommended and so on and so forth. But that doesn't in any way prevent the decision maker who is dealing with someone charged with an offence under these regulations from reaching a decision. And that, in my submission, is the way one should test this. Think about a particular instance of somebody being prosecuted who says, well, I was attempting, or I was organising the gathering and I tried to comply with the guidelines, or indeed I was complying. Let's take it at its highest. I was complying with the guidelines. Well, that must be capable of determination either way, just in the same way that the Motor Vehicles Act takes it as read that one can answer the question whether somebody has observed or not a provision of the Highway Code. A failure to observe any provision of the Highway Code may be relied upon by any party. One doesn't hear in response to that the protest, well, how can you tell whether you've complied with the Highway Code? Because the Highway Code says should rather than must. I mean, if the Highway Code says you should give way to somebody at a certain sort of crossing, then that's what you must do for the purposes of being able to say that you complied with the Highway Code. And similarly, in these guidelines, if it says that you should give people the option to attend, elderly people to attend services separately, then it's pretty clear whether you have or haven't complied with that. But even if one gets into some area where there's a room for debate, take that one, who are elderly persons for the purpose of this is not defined. So what point does one become elderly? Well, the answer there lies in my submission in the overarching point that this is all subject to the requirement that the conduct be without reasonable justification. So in any instance, one can imagine if it's a person who's organised the event is being prosecuted, if the person can say, well, look, I looked at the guidelines, I took the view that what was required was this, this, and this, a finder of fact should be able to tell whether the guidelines have or haven't been complied with. And in any event, there is the requirement of the prosecution to knock out the contention that there was reasonable justification for acting as the organiser did. And in a sense, that applies that applies even more strongly if one is merely the person attending an event. I mean, plainly, if one gets an invitation to go and attend a wedding while this is all in force, and you turn up and there are stewards on the door making sure not too many people come in at the same time, and there are things for hand sanitizers, etc., then you might be in a reasonable position to say, well, I had reasonable justification. And once you've said that, the prosecution might have some difficulty in knocking that down. On the other hand, if you turn up and it's obvious there's a riot underway, then you're going to get pretty short shrift. But and it might be said, well, that's all a bit uncertain, but that's built into the notion of reasonable justification. It's one of the ironic features of this challenge that all of the focus is on the fact that the guidelines themselves are said to be too uncertain to constitute proper criminal law. But at the same time, there's no quibble with the fact that the offence contains this question, this element that has to be proved if it's raised, has to be proved against the defendant if it's raised by the defendant, namely without reasonable justification.
So if the
which is completely
guideline,
open-ended.
the guideline says something you do, like insure or provide, it's not what you should do, actually says what you do, how does that fit into reasonable justification if you don't?
Well, it depends. It depends who you are, I suppose. If you are
the organiser, and
if you're the organiser, and your
your sanitizer is 50% alcohol based or whatever.
Well, again, one has to look at this, each particular one, I suppose. But let's okay. So,
Or there's no separate storage for your footwear.
well, in each case, it permits the. Whatever the fact, it's always open to the defendant to say, well, I attended with a reasonable justification, or I organised this with reasonable justification. The extent to which a failure to comply with the guidelines, in practice, knocks that, or enables the prosecution to knock that element to establish that element of the offence, the failure to have reasonable justification, depends upon the provision that one looks at. No doubt if inadvertently you'd provided 50% alcohol-based sanitizer, if there is such a thing, then, I mean, for a start, one would have to. One would expect.
It's all a guideline, none of it's mandatory, or what?
No, it's well, it's at the level of guideline. It's all guidelines. Yes, at the level of whether the offence has been committed, then it will generally be possible to say one way or the other whether the guidelines have been followed. I mean, the 50% sanitizer might be a de minimis point. You might say, well, that's in reality. But suppose that as the organiser you completely forget about calculating attendance based upon 36 square feet per person and just say, let's just get as many people in as we can. Well, then you can't possibly say you've complied with the guidelines. And so it doesn't mean you're out altogether, because you could still, without reasonable justification, is unlimited. It's not just tied to the guidelines, but you might struggle in those circumstances. But if you've ensured that 36 square feet per person is allowed to everybody, then in that respect you have complied with the guidelines. And similarly for any other provision that is here. My point is that in practical terms, it will, in every case that one can conceive, I would submit, be workable for a tribunal of fact to decide whether or not it is the case that the gathering complied with the guidelines. Just as it is possible for a tribunal to decide whether a driver complied with the highway code, notwithstanding that it has some provisions which are in less than absolute terms. You need to leave a reasonable amount of room between you and the car in front when you're driving along, according to the highway code, I think. That's no one says, well, that there's inherent uncertainty in the Motor Vehicles and Road Traffic Act because of that. It's left to the good sense of the trier of fact to decide whether the rule has been complied with or not, whether the guidelines have been complied with or not. And so the ultimate consequence of all of that, in my respectful submission, is that A, there is no difficulty formally with the scheme that was adopted by the government. This was a regulation that was properly published in the Gazette, and it was no less so by virtue of the fact that it, by reference, made relevant to the consideration of a charge whether somebody had or hadn't complied with the guidelines, and B, there is no substantive problem with it because it's merely one example among many of a situation where the law requires a trier of fact to consider guidelines and form a view one way or the other as to whether or not they've been complied with. And C, in any event, it's all subject to the need to prove that a person didn't have reasonable justification. And so, in any hard case where it might be said that it would be unjustified for somebody to be at a particular event, or in any hard case where somebody's at an event and it's clear that the guidelines haven't been complied with, there's nevertheless still that requirement on the prosecution to disprove the or rather to prove the absence of a reasonable justification, to knock down the evidentially raised justification. So, my lord, my ladies, my lords, my lady, for those reasons, we respectfully submit that the regulations ought to survive the challenge. May I take one moment? I'm reminded by Mr. Hussain that we are dealing with a historical question here, because the regulations, as we've seen, have gone through a variety of different iterations. And so if the board were to be against us on the substance of the challenge for whatever reason, then in framing the declaration, or whatever it is that the board would be minded to make, one ought, in my submission, to take into account the essentially historical nature of the point of the provision, so as to make clear the board isn't, as it were, legislating for other cases that are not covered by this specific regulation. But it may be, if and when we get to that stage, it may be that the board will be sympathetic to, albeit very brief, further written submissions about remedy.
Yes. That's what I was just about to ask about that, actually, but you may want to leave it for written submissions. What was going through my mind was whether, I think the way Mr. Ramlogan puts it is that we might remit for the assessment of damages, but I wondered if there might be an issue as to whether an award of damages is in fact appropriate, even if there is a breach of the Constitution, and we ought to remit that issue also.
Yes. And I think that would surely be right. Well, either omitted, or I suppose the board itself could consider that issue. But since that hasn't been considered by the courts below, I expect Your Lordship would probably say it's the courts below that should first opine on the question.
Yes, I'm not sure that there are findings in fact that would form a basis for saying that all that remains is the assessment of damages.
No. The question would be...
You know very, very little about the factual circumstances behind this challenge.
Yes. I think on reflection that must be right, my lord, that any remission should be, well, A, it's probably not a matter the board can deal with itself. B, any remission should be to the lower courts to decide whether any, or to deal with any issue that arises as to damage. And we'll need to go back and look at precisely how it was framed in the courts at first instance, and what
the issue of damages was left over.
What's open, yes.
Yes, thank you very much.
And for those part, those are my submissions.
Okay. Yes.
My Lord, may I reply very briefly?
Yes, Ms. Riley.
Principally on one point, which is this. I think it was said by my learned friend towards the beginning of his submissions that the role of reasonable justification is essentially part of this offence. And we would wish to make this point: it is not part of the offence. It is plainly operating, we would respectfully submit, as a defence. And that is of some legal import, because once it is operating as a defence to the criminal offence created, what that means is that that is not the aspect of the provision against which the court should be applying the principle of sufficient certainty. It is the elements of the offence which are to be assessed against the principle of sufficient legal certainty. There may well be cases where a statutory defence is articulated in a way, for example, by reference to certain factual scenarios. And in such an example, it may be that the way the defence is articulated has the effect of narrowing the ambit of what the offence is. But that is not the case we are dealing with here.
What authority do you have for saying that the without reasonable justification is something that has to be pleaded by the defence rather than excluded by the prosecution?
Well, what we say is that it is the elements of the criminal offence in issue which must be assessed against the principle of legality. And we get that, for example, from the case of McEwen, which the court will see at page 3308 of the Suraj bundle. Paragraph 80. Where the court there said this was a decision of the Caribbean Court of Justice, a penal statute.
Yes, but there are cases prosecuted, tried every day in the courts to do with, for example, possession of a knife or an offensive weapon,
Yes.
or having about you the tools of, I forget the precise wording, but effectively having a burglar's toolkit with you. And they're all subject to without lawful excuse or without reasonable justification or
Yes.
whatever it may be. And certainly in my recollection, the prosecution do have to establish the absence. I mean, it's hardly
Yes.
a very demanding thing unless the defence put forward some sort of justification.
Yes.
But the legal theory of it is that the absence of lawful excuse, etc., forms part of the offence.
Yes, my lord is right. The prosecution bear the burden, and that is the issue that was dealt with in the case of Charles, which I think was referred to a few moments ago. But there's a distinction between who bears the burden and how that operates, and whether the elements of the offence itself are sufficiently certain. So, of course, there's some interaction between what the defence is and what the elements of the offence are.
I don't see that. I mean, if the exclusion of without reasonable excuse is not an element of the offence, why would the prosecution have any burden at all? It would just say there were more than 10 people there, full stop.
But what we say is, because it's a defence of justification, one has to focus on the wrongful conduct that's said to be caught by the offence.
But you say it's a defence of justification.
Yes.
It isn't. It is a component of the crime. One has to exclude the possibility, beyond reasonable doubt, of there being a reasonable justification.
Yeah.
Yes, but the difficulty is that because of the wording of subsection 2, because of the way it defines the offence by reference to the guidelines, what the respondent has failed to grapple with, we would respectfully submit, is the inherent ambit of that defence, because what they have not grappled with respect, is how that defence is to operate against the innumerable permutations and combinations of how any person might breach the contents of the guideline. And so really, insofar as the defence is available, bearing in mind where the burden lies, we would respectfully submit that it doesn't offer any cure to what we say is the inherent vagueness of the offence.
So you're saying whether it's a defence or whether it's something which I think the defence has the burden of raising it.
Yes.
But then it's the prosecution has to show beyond reasonable
Yes,
doubt.
the evidential burden.
The evidential burden.
Yes, and the persuasive burden would then
Yes.
follow.
But are you saying that whichever way round it is, the uncertainty is as offensive to the constitutionality of the offence, whether or not it's uncertainty as to when a defence arises or as to when the element is made out?
Yes, my lady. It doesn't offer any cure to what we say is the inherent vagueness of the provision in any event. And one would only be in a position to invoke the defence of reasonable justification at the point of charge. And we know from the case of McEwen, again, at paragraph 81, going back to 3308, that the provision of particulars after charge do not cure the problem of insufficient certainty in the offence itself. I'm sorry, paragraph 82, page 3308, where the court said, It was suggested to us by the Solicitor General that any potential vagueness could be removed if, when a person is charged, details are given of the improper purpose, and it was the improper purpose that was at issue in the legislation at issue in that case. This is not an effective solution to the problem. It seeks to cure the vagueness after the individual has been arrested for the offence. And so again, one has to consider that insofar as the defence is available, it would only be invoked at that stage, and by that stage it's too late, we would submit. Those would be the submissions we would make in reply.
Thank you very much, Ms. O'Reilly. Well, these are important appeals. We're very grateful for the assistance we've received from all counsel and no doubt from those sitting behind counsel also. We'll take time now to consider our judgment.